Welcome to the Clow Center Constitutionalism, Climate Constitutionalism series. I'm David Worth. I am a professor at the law school, and it is our immense good fortune today to have Professor Barry Hill speaking to us about constitutional environmentalism and environmental justice. Before I introduce him, just two procedural issues. The first is that this event is being recorded. That's the required notice under Massachusetts law. And also, Professor Hill has kindly agreed to take questions, but they will be moderated. So as he is speaking, you're welcome to queue up questions in the Q&A. They'll come to me and to him, and after he has finished his prepared remarks, then they'll be presented to him one by one. So Professor Hill has had an extensive legal career in the public and private sectors, as well as in academia. He has had two stints at the U.S. Environmental Protection Agency. In particular, he was the head of the Office of Environmental Justice from 1998 to 2007. He has done an environmental justice course at Vermont Law School for 24 years, where I've had the immense good fortune to have him as a colleague. We get to see all too little of each other when we're actually there, but it's my sentimental wearing of the Vermont Law School tie in honor of the occasion and his presence today. He has written extensively on the topic of environmental justice and is currently working on the 5th edition of his textbook, Handbook, Environmental Justice, Legal Theory and Practice, which will be published in the spring of 2022. He has lectured in the Middle East, Africa, South and Central America, just about every continent, and the Caribbean on a variety of environmental law and policy topics. So Professor Hill, Barry, an immense pleasure and honor to have you with us today, and over to you.
Thank you, David. I'm sorry that we could not do this in person, but we will do the best that we can under the circumstances. As David said, this presentation is about constitutional environmentalism and environmental justice. My presentation is divided into 3 parts. The first part is legislative environmentalism. I'm going to use it as a basis for trying to help you understand what constitutional environmentalism is and how it's different. And then I will make some concluding remarks. So first, legislative environmentalism. In front of you, I have a triangle, which helps to explain what legislative environmentalism is all about. At the bottom of the triangle, it starts with environmental laws. This is consistent with our representative democracy. Environmental laws are created by Congress, which is the most democratic body. It's the largest body in our government. It moves from the legislative to the executive branch, where there's compliance and enforcement and the development and implementation of environmental policy. Then you have the rule of law, the judiciary. If you have all of these entities functioning, you have what they say, what they call good environmental governance. And the goal is to protect public health and the environment. Now, I call this the age of environment as it relates to the modern environmental movement. The first stage began at the turn of the century. The leaders at that particular time were people like John Muir, the Scottish immigrant who founded the Sierra Club. He's considered the father of national parks. And then we have Aldo Leopold, the forester. He's the father of wildlife ecology. The primary focus of these leaders at that time was to conserve the environment, the pristine environment. President Teddy Roosevelt was an ardent conservationist. He was very helpful as far as moving forward with this whole notion of national parks. The second stage began in the 1960s into the 1970s. All of the environmental laws were created during that particular period. The leaders during that period were lawyers in the executive branch, as well as lawyers in Congress drafting these laws. The third stage arguably happened in the 1980s until the present time. The leaders there are community people who are focused on hazardous waste and clean air, clean water, things like that. Now, the one thing about this age of the environment, or of the modern environmental movement, is that the environmental issues triggered the legislative responses. I'm going to go through this fairly quickly. So we have air pollution, poor air quality, traffic emissions, smog. You have the Clean Air Act, 1970, the second stage of the environmental movement. You have a woman there, in Los Angeles going through the smog. It's very difficult. You see her wiping her eyes. Chemicals, that's another issue. Exposure of children and elderly to pesticides, dumping of chemicals. Congress responded with TSCA, RCRA, and the Safe Drinking Water Act in 1974. You have the Cuyahoga River being burned because of an oil slick in June of 1969. Hazardous waste, the dumping of hazardous waste onto land. You have CERCLA in 1980. You have SARA, the amendments in 1986. You have Love Canal, New York, the environmental disaster in the 1970s. Industrial dumping of drums leaching content into backyards from Hooker Chemical Company. Then you have the national priorities list of the worst Superfund sites, where a lot of these drums are leaching into the groundwater and destroying people and their health. We have oil spills. The Oil Pollution Act of 1990, this was an amendment to the Clean Water Act of 1972 after the Exxon Valdez oil spill in March of 1989. There's the Exxon Valdez oil spill. Obviously, wildlife was impacted negatively as a result of the oil spill. Then you have the Deepwater Horizon. That's an industrial disaster, 4.9 million barrels of crude oil on April 20th, 2010 in the Gulf of Mexico. Obviously, a lot of wildlife was impacted, as well as people. What happens, however, when these environmental laws, the structure does not work for minority and low-income communities? That's why we have this thing called environmental justice movement. You've heard of Flint, Michigan. It's the poster child as far as environmental injustice is concerned currently in this country. 12 people dead, 90 people contracted Legionnaire's disease as a result of bacteria and lead leaching into their drinking water. You have in front of you the New York City Rally for Climate and Racial Justice. It's because of the fact that the system does not work the way it's supposed to work based upon legislative environmentalism. So you have to come up with a new regime, if you will. That's when we get into constitutional environmentalism. Triangle, we start with constitutional law instead of environmental law. You have the same process as it relates to the executive branch, the judiciary. You have good environmental governance, and the goal is this whole notion that everyone is entitled to clean land, clean air, and clean water based upon the Constitution. Now, based upon the David Suzuki Foundation, we look at national constitutions and subnational constitutions. 149 out of 193 countries have in their constitutions, national constitution, environmental rights and or member responsibilities. Now, 96 of those 149 countries have a substantive human right to a clean, safe, and healthful environment. It doesn't exist here in the United States in our national constitution, so that's why we have subnational constitutions, state ERAs. You have Illinois in 1970, Pennsylvania in 72, Montana in 72, Massachusetts in 72, Hawaii in 1978, and Rhode Island in 1987, currently. Now, what is an environmental rights amendment? Basically, it's an amendment in the state constitution giving people the right to a healthful environment, clean air, clean land, clean air, and clean water. Currently, 1/3 of the states in the United States have something in their constitution or in another document that talks about environmental policy. That's the pink states that you have in front of you. Then the purple states, that's Illinois, Massachusetts, and Hawaii, they have ERAs, but they're outside of the Bill of Rights section of their national constitution. Then you have the green states. You have Montana, Rhode Island, and Pennsylvania, where the Environmental Rights Amendment is in the Bill of Rights, together with the right to bear arms, the right to equal enforcement of the law, the right to religion, et cetera, et cetera. That's where many states want to, that's where some states want to have their ERAs. New York may be joining that group of states beginning in November of this year, as a result of a referendum. What we're going to do is look at Pennsylvania, Illinois, and Hawaii quickly and see what it says in their constitution. Pennsylvania's ERA, as I said before, is in its Bill of Rights. Pennsylvania ERA has a trusteeship provision in it. Illinois and Hawaii, they stipulate that legal enforcement of the right against any party, public or private. Illinois, Article 11. The public policy of the state and the duty of each person is to provide and maintain a healthful environment for the benefit of this and future generations. The General Assembly obviously is going to have to provide law for the implementation and enforcement of this public policy. It is not self-executing. It needs the General Assembly to pass legislation. Each person has a right to a healthful environment. Each person may enforce this right against any party, governmental or private. Pennsylvania, it's in the Bill of Rights. People have a right, not a privilege. A right is something that cannot be taken away from you. A privilege is something that can be taken away from you. Let me use this as an example. Driving. When you get to be 18, you do not have a right to drive. You are granted a privilege as long as you pass the driver's exam, the written exam, whatever the case may be. That privilege can't be taken away from you if you do not comply with the rules of the road. But in this situation, we're talking about a right and not a privilege. Now, I said before that Pennsylvania has a trusteeship provision, and it says Pennsylvania's public natural resources are the common property of all of the people, including generations yet to come. As trustee of these resources, the Commonwealth shall conserve and maintain them for the benefit of all the people. So you have a self-executing right, but as it relates to the trusteeship, you have the Commonwealth of Pennsylvania controlling it. In Hawaii, each person has a right to a clean and healthful environment, as defined by laws relating to environmental quality, including control of pollution and conservation, protection and enhancement of natural resources. Any person may enforce this right against any party, public or private, through appropriate legal proceedings subject to reasonable limitations and regulations as provided by law. So I would say that this is constitutional environmentalism plus. That's what is needed at this particular point in time as it relates to minority and low-income communities and what they call sacrifice zones. That's what the UN calls it, people living in sacrifice zones. So instead of just environmental law or constitutional law, at the bottom of the screen, you have environmental rights amendments, climate justice laws, and environmental justice laws. It will go through the same process. The executive branch compliance and enforcement, and the development and implementation of policy. You have the judiciary regarding the rule of law. Again, if all of these aspects of the system is working, you have good environmental governance. Assuming that that works, assuming that everyone is consistently doing their job, you can have climate and environmental justice. New York is a state that seems to be moving in this direction. Let me share with you that I am working with groups in Maryland to try to get an environmental rights amendment passed in that state. We had hearings before the House as well as the Senate in January and February of this year. Hopefully, it will be reintroduced next year, which is an election year. And then things could move forward as far as the people of Maryland are concerned. In New York, we have an environmental rights amendment. Each person shall have a right to clean air, water, and a healthful environment. It is self-executing. That's it. Those words represent what New York is saying as it relates to its environmental rights amendment. Each person shall have the right. Now, the question is, in all these situations, how will the state enforce it? How will citizens groups, how will individuals and communities seek to have their right to clean air, water, and a healthful environment? How do you define a healthful environment in New York? You have this thing called climate change. How is it affecting the people of New York, the state of New York? Under these circumstances, how can the government ensure that each person can have that right and it is enforceable? A lot remains to be seen. In New York, as I said earlier, in November of this year, there will be a referendum. Hopefully, the people of the state of New York will vote in favor of Article 1, Section 19, being placed in the state constitution in the Bill of Rights section of New York. You have environmental justice legislation. Article 48 of the Environmental Conservation Law. On January 1st of last year, the environmental legislation was enacted into law, signed by the governor. It's a very expansive and comprehensive piece of environmental justice legislation. And finally, we have climate change legislation in New York. Climate Leadership and Community Protection Act. That was in July of 2019. So if you go back to the slide that I showed you, you have environmental justice law, climate justice law, and environmental rights amendment in New York. If, again, we start with those laws as the basis of this regime, and the executive branch and the judiciary are supposed to be doing their thing, we can have, theoretically, climate and environmental justice. Concluding remarks. Addressing environmental and climate justice. As of today, there are very few environmental and climate justice cases that are utilizing the Environmental Rights Amendment. There is a case that was brought by the Rhode Island Attorney General's office, because as you know, Rhode Island has an Environmental Rights Amendment. And in the complaint, it was brought against Chevron and a number of other big oil companies. It's going to be impacted by the Baltimore case that's before the Supreme Court. And the question is whether or not a state can proceed in state court, a state AG can proceed in state court against a multinational corporation based upon the impact to climate. It's a very comprehensive complaint that was filed against Chevron and these other oil companies, big oil companies. So we'll see what the Supreme Court is going to say by sometime next year. You have the AG's office from the District of Columbia. You have the AG's office from Minnesota. They filed complaints against big oil companies. They do not have ERAs, but they talk about environmental justice and climate justice in their complaints. Again, that will be impacted by the court's, the Supreme Court's decision in the big oil case against these states, but it seems as if there's a lot of effort to try to address environmental justice as an issue. As of today, environmental and climate justice is a new focus of legislation. I talked about Maryland as far as an ERA is concerned. We're also talking about environmental justice legislation. It is important to have coexisting legislation in order to move to address these issues, not only climate, but also environmental justice, because the scheme that we talked about at the very beginning of this presentation, legislative environmentalism, it has not worked. If it did work, you would not have millions of people living in these sacrifice zones who happen to be minority and low-income people. There is a reason why these pollution-generating facilities seem to be placed time and time again in these types of communities. As a result, they're being impacted negatively as far as their health is concerned. Yes, you know, there's an argument that it has not been shown categorically that your environment affects your health. But common sense also demonstrate that this is reality. Why is it that these communities are sick communities, if you will? So if I want this to be an interactive discussion rather than just me talking, I think that's when we can have more information that might come out and I can respond to your concerns. But if there's anything that the message that I want you to leave with you today is that coexisting legislation arguably is a way to go. That will make a difference as far as the lives of people are concerned. And it's not just in the United States. As I said, in so many other countries, they have this notion of a healthful environment in their constitution. But the problem is enforcing it as a practical matter through the courts. There has been litigation, particularly with respect to climate change, in Sweden and other places where this has been done. So there's hope, but we have to keep working at this in order to make a difference in the lives of millions of people. So with that, thank you. David, I turn to you for any questions that people might have.
Thank you, Barry, for that very enlightening and hopeful presentation. What you're describing is a new generation of environmental lawmaking on the constitutional level, both state and federal, and subject matter, as well as an expansion to include environmental justice issues. Very, very exciting. There were the Q&A is open. Please do submit your questions. There were two that came in that I think provide, I think Barry's concluding observations provide a terrific transition to them. How long, and the questions are, how has the history of the United States affected current climate and environmental activism? And then a related question, are there noticeable overlaps between states with deep histories of slavery and states with climate injustices? So over to you.
Well, the environmental movement, as you well know, at the beginning of the 20th century was rather interesting. I mentioned John Muir, the Scottish immigrant, who is the founder of the Sierra Club. And what I'm going to talk about is the tension between the traditional environmental movement and the environmental justice movement. This is from an article, July 24, 2020. Inside Hook article is entitled "The Environmental Organization John Muir Founded is Coming to Grips with His Racism." I'm just going to read it. The same man who cared so dearly about the rivers and trees he spotted on hikes in the California wilderness has surprisingly little compassion for the people who lived there first. In his writing, Muir called indigenous people dirty, deadly, hideous, lazy, savage, and wife-stealing. A paper published in the American Indian Quarterly in 1978 details how Muir's attitudes on Native Americans gradually shifted. Moore once wrote, "Perhaps if I knew them better, I should like them better. The worst thing about them is their uncleanliness." So further, with respect to Black people, the article states the Sierra Club remained an exclusive society. Long after Muir died in 1914, membership was contingent on sponsorship from existing members until the 1960s. This exclusion applied to Black Americans too, who Muir also had some choice words for in his time. John Muir once wrote, "One energetic white man working with a will would easily pick as much cotton as half a dozen Sambos and Sallys." As you know, Sambo is an outdated derogatory term for people of African origin. In another instance, sitting with two Black people at a campfire, Muir wrote, "I can see their ivory gleaming from their great lips and their smooth cheeks flashing off light as if made of glass. Seen anywhere but in the South, the glossy pair would have been taken for twin devils, but here it was only a Negro and his wife at their supper." Obviously, the Sierra Club has sought to address this issue as far as naming more people of diversity in their leadership ranks. Now, what has happened is that there has been this split between the environmental movement, the traditional environmental movement, and the environmental justice movement, which began basically, as far as national attention is concerned, in 1982 as a result of the PCB landfill in North Carolina. In 1990, there was a letter that was written to the leadership of these traditional environmental organizations from the Southwest network saying that there is a problem. What has happened is that the issues are very different. The environmental issues from the traditional environmental organization and public health issues as it relates to the environmental justice movement. Hopefully, there seems to be, they seem to be working better together, but we shall see as far as time is concerned. Now, there are problems as far as the South is concerned, but there are also problems as far as the North is concerned. You have industry being cited next to communities of color because of lack of power, lack of access, lack of understanding, whatever the case may be. And it was the path of least resistance as far as these corporations are concerned. You have to look at a permit as a license to pollute. If my company is large, then the permit will allow me to pollute but so much and no more. But what if you have a number of facilities being cited in the same kinds of communities time and time again, whether in the South or in the North? The problem is that, as I said before, the environment affects public health of the people, defense line communities living next to these facilities. You look at Cancer Alley in Louisiana, that 90-mile stretch from New Orleans to Baton Rouge, petrochemical companies every place. It's essentially the sky is lit up in the middle of the night because of the flares. But people live there on a daily basis and they breathe that air. That's why they do call it Cancer Alley. So I would not say that it's just based upon slavery. It's racism. That's what the environmental justice movement, that's how it started. It said environmental racism. That was a term that was used. Then it became environmental equity. That was the term that was used by EPA. But how do you determine equity if you do not have power and authority to enforce equity? And so now it's environmental justice, because that's the term that everyone can understand, justice. So it's a long-winded answer to a rather general question. I hope I've answered some of the concerns that you might have in that question.
All right, thank you for very trenchant answers and observations. And there are others that the Q&A is hopping. A couple of themes that are popping up. Here's one. What about mainstream environmental organizations, where you talked a little bit about the history of the Sierra Club, but where are they now? Where should they be? This is my personal perspective, having worked in one, is that environment is not just a legal construct and also an area of legal practice, but also a social policy movement with a considerable amount of momentum. So what advice would you have for mainstream groups, Sierra Club, my former employer, the Natural Resources Defense Council, going forward?
I think one of the most important things is diversity in leadership. I'll use this term or phrase that the Reverend Jesse Jackson used to use. You can't teach what you don't know. You can't lead where you don't go. With that simple phrase that he used, he really talks about leadership. And if leadership is listening from so many voices, whether or not they're indigenous or from minority groups, and they're part of the leadership of these organizations, I think it could make a tremendous difference. But you have to be able to be seated at the table. Elizabeth Warren has said that if you're not at the table, then you're on the menu. And she was right in so many respects. So if the leadership, white, black, indigenous, whatever, are at the table in these environmental organizations, then there's hope because people will listen. And if you listen, you will act, you will implement. But if you do not hear, if you do not have various people at the table, then you're going to have problems. If you look at Earth Justice, I was looking at their website before I had this presentation in responding to someone else's an email, and I was just going down the who we are, that type of thing. And you see in Earth Justice, which is a public interest law firm, you see diversity in VP positions, senior attorneys, whatever the case may be. As the attorney in the Chauvin case said, a bouquet of humanity. Those were the people who were looking at what happened to George Floyd. And as I looked at Earth Justice, their website, it was a bouquet of humanity, and it was beautiful. So that's what's necessary, I think, David. Diversity in the leadership.
All right, and then another theme, Barry, building on some of the points you've touched on. Can you talk a little bit more about what sacrifice zones are? How might they be addressed through changes in federal legislation? And also, how can we be sure that the legal tools that are created to address them will be used to advance claims and protections by vulnerable communities, and not just as a way to protect the existing environmental interests of wealthier middle-class communities who may have better access to litigation resources?
Well, the term sacrifice zones, as I said earlier, came from the United Nations. They put out this paper, and they're currently doing a study as we sit here, looking at sacrifice zones and the way in which they describe sacrifice zones. They sound like environmental justice communities, what we call environmental justice communities, minority and low income populations. And it's the poor that are impacted greatly. Now, we will see what the study will produce as far as recommendations and things like that. I believe that sometime later this year they're going to issue this. But it seems so consistent with what has been said here in the U.S. by the leadership of the environmental justice movement. So, and as you said, David, I'm working on the 5th edition of my textbook, and in the introduction, I talk about sacrifice zones, and I use that particular terminology throughout the 1,000-page book or so to explain what is really happening. And they are sacrifice zones. If you think about it, sacrifice for sake of industry, for the sake of the dollar. They're basically saying that the lives of these people, these fence line community people, they don't matter. And the problem is that EPA, using EPA as an example, it does not have the authority to tell an applicant who wants to site a petrochemical facility, no, you cannot site your facility there. We think that you should site your facility someplace else. EPA does not have that authority. Now, one of the things about NEPA, which is a procedural statute, which is the mother of all of these modern environmental laws, it was enacted in 1969. NEPA talks about cumulative impacts. The President's Council on Environmental Quality issued regulations back in '78 and at other times. So they talked about cumulative impacts. This is something that you need to take into consideration in preparation for this federal action. But as you know, the Trump administration eliminated entirely the whole notion of cumulative impacts. For the first time, these regulations have not been changed in 40 years, but now they're final at this particular point. So what is the Biden administration, what are they going to do with this issue? Communities have relied on cumulative impacts to make their arguments, to say that, look, we are a sacrifice zone. We are, we have all of these petrochemical companies. We have this, we have that. We have everything. Cumulative impacts that can be used to slow down the siting of a facility. It has been used in several cases. But because of that regime being changed so significantly, what's going to happen to those communities if they cannot use that argument as it relates to NEPA? It's a procedural statute, but that just shows, that absolutely shows what I was talking about earlier in this presentation. Legislative environmentalism, theoretically, it works for everyone, but it has not worked for all communities. So that's why there has to be a different regime altogether, based upon environmental laws, based upon constitutional law, climate law, as well as EJ legislation. That's where there's some hope.
Sorry.
David? Okay.
Sorry, I was muted. I'm here. Sorry, I was muted. Barry, you're seem to be prepared to take on some pretty challenging issues. So here's, for which we are most grateful. And here's one. Could you elaborate more on your point that a healthful environment is a right and not a privilege? And also, I'm taking two questions and eliding them. What does that actually mean in practice? And so one of the questions that came in was, what about sea level rise in New Jersey? Suppose sea level rise disproportionately affects minority communities near Atlantic City, where the actual tourism and casino industry is on the higher land and state funds are going to protect the industry and is not being directed at minority communities who are going to suffer disproportionately from sea level rise. So in other words, what does it mean for a clean, a healthy environment, a sustainable environment to be a matter of right, and how can it be implemented in actual practice, either through litigation or otherwise?
I wish I had a crystal ball to respond to those two questions, because that's how I see the two questions. First of all, and in September 2020, New Jersey has enacted the most comprehensive piece of environmental justice legislation in the country. They speak in terms of cumulative impacts and what the New Jersey Department of Environment must do under those circumstances. So We shall see as far as the regulations and the implementation of policy as it relates to that particular piece of legislation. As you were talking about New Jersey, I immediately thought about Florida. Florida is surrounded by the Atlantic Ocean and the Gulf of Mexico, major bodies of water, if you will. Miami is inundated with rising sea level on a daily basis. And not only Miami, but practically throughout the entire state. Now, 90% of the people in Florida rely on groundwater for their drinking water, for their bathing purposes. Now, what happens if the groundwater is mixed with seawater? You can't use it, you can't drink it. You have a problem living because water is used by people, plants, nature, whatever the case may be. It is absolutely necessary. The water is rising as a result of climate change. We've been talking about this for the last 20 years. Now, what's going to happen to the people in Florida? We also talk about climate refugees. Well, many of the people in Florida, what will they do? Will they go to Georgia? Will they go to other places in order to survive because they have no water to drink as a practical matter and the sea continues to rise? How do you apply the law under those circumstances as far it relates to climate change? What is happening right now is that little Haiti in Miami is now becoming a focus of concern, or focus of interest, not concern, a focus of interest for real estate developers. Why? Because it's on higher ground. It's not being impacted the same way that other parts of Miami are being impacted. It's a temporary solution, if you will, because the sea will continue to rise. But what do you do with the rights, if you will? Right now, it's a privilege to live in a clean and healthy environment. Florida doesn't have an environmental rights amendment, but even if it did, how do you apply it as a practical matter in a court? I don't know. I don't know. But that's the reason why you had the environmental movement looking at legislative approach to the environment. Now remember, we're talking about the 60s and 70s. At the same time, you have this effort dealing with environmental rights in the constitutions of these various states. 72, 70, the latest was Hawaii in 86. They came in the third stage of the modern environmental movement. It seemed as if it was a parallel track. If you look at a railroad track, for example, you can look as far as the eye can see. It appears as if the tracks come together visually. But as you continue to walk, you'll see that there are ties that bind. They never come together. But what you're seeing right now is that there is a coming together, because the ties that bind, it's human health, it's clean air and clean water. That's why these there has to be this coexisting legislation, and they must work together. It'll be up to creative lawyers, young lawyers at Earth Justice and other places who are doing this kind of work, who can see the connection between these various laws. In the litigation that I talked about earlier, the climate change litigation brought by the Rhode Island AG's office, as well as Minnesota, as well as the District of Columbia. They've been very creative in putting the complaints together. They talk about environmental law. In Rhode Island's case, they talk about the Environmental Rights Amendment. They talk about public trust. They talk about public nuisance. So you have these creative lawyers seeing that there's a connection between all of these laws. And so they're using each and every regime that they can in order to get what it is that they want for the people of that particular state. So I think we're moving in the direction of more of a right than a privilege. I talked about Maryland, but there are other states. You have New Jersey, New Mexico, Vermont, Washington State, West Virginia, Kentucky, Oregon, and as I said earlier, Maryland. All of those states are considering bills that have been introduced talking about rights, constitutional ERAs. It's moving away from privilege to a right. They're looking back at what these other states had done in the 1970s, and they're just modernizing it. And they are defining what a healthful environment means in today's world. It may be very different from what a healthful environment meant in the 1970s when these ERAs were first introduced. So it has to be consistent with the times. That's what I'm essentially saying, but I think it's moving in the direction of rights instead of privilege.
Yeah, if I could just exercise the prerogative of the moderator and add a small point. If one looks abroad to countries like South Africa and India, one sees a fair amount of progress in the courts. So for instance, the Supreme Court of India has an environmental chamber that's devoted strictly to hearing in environmental cases, such as one famous one dealing with the Taj Mahal. The Supreme Court of South Africa is very active in what are called second generation rights, economic, social, and cultural rights. And there's a famous decision in the past few years out of a Dutch court where the court ordered the government that to increase its, what we would call in the Paris climate agreement setting, increase its ambition from 20% to a minimum of 25 to 40%. And so the question, Barry, I think for us then is, looking around the world, I think we see judiciaries that are receptive to many of these concerns. We also see them in international tribunals, such as the International Court of Justice. On the other hand, in the United States, maybe not so encouraging. The sorts of situations that I just ticked off, I think would be described as judicial activism in the extreme, and attract a great deal of negative attention, much as Sierra Club Legal Defense Fund, you and I might like it. So I was wondering if you have any thoughts about how to bring, I mean, we've talked about different sectors of society, non-governmental organizations, disadvantaged communities. How do we go about bringing the judiciary on board, so to speak, to get back to something like the mindset, to use a term from that period, that we were in 1970, when the courts saw themselves as in the vanguard. And now it seems to be a lot of times the courts are the problem rather than the solution.
Well, in the Uganda case that you talked about in Sweden, they had environmental rights. That was part of the equation. So it made the judiciary, it gave an opportunity to be more creative, let's say, as far as the law is concerned. If you look at Juliana, the case out of Washington State, the Court of Appeals, the Ninth Circuit Court of Appeals, said there is an issue called climate change, but based upon decisions by the Supreme Court, that's something that should be left to the executive. That's the same argument that's being used in the other cases that I mentioned in DC, Rhode Island, Baltimore, and other cases, that it's a federal question. It should be up to EPA. It should be up to the executive branch in order to find solutions. So therefore, we can't act. So while there's this reluctance to act because of the process, the world is going to continue to be negatively impacted by climate change. And the sea will continue to rise, whether or not it's in Florida or New Jersey or whatever the case may be. That's why the AG in Rhode Island acted, because it was affecting the fishing rights and the ability of people to live, to survive. And they were being flooded as a practical matter. So creative use of the laws that you have in front of you, that's what it's going to take. Now, just imagine for a moment if the state of Washington had an environmental rights amendment when the Juliana case was filed. Totally different experience if the matter was being held in Washington State Court rather than federal court. Because federal court, you run into the problems that I talked about, the reluctance for the judiciary to move. I don't know what the answer is as far as the Supreme Court is concerned. But it's a problem that's continuing to loom. And if you keep saying that it's up to the executive branch to address this issue and the executive branch doesn't, well, what does it mean as far as the rest of us are concerned, as far as humanity is concerned? Where did we go? What do we do under those circumstances? I don't have the answer.
Well, here's one where you no doubt have some thoughts and some advice to the audience here, which includes undergraduates, graduate students, including law students, but not just law students, as well as faculty and administrators. You've been very generous with your insights and time. What would you advise, particularly those who are just starting out their careers now, as to where they can best make beneficial contributions to the further development of both public policy as well as individual initiatives in this area?
I think it's important for young people to put on their thinking caps. Older lawyers like myself, all we can do is light a candle. All we can do is teach, write, do things like that. But it's up to younger people. In the book that I'm working on, ordinarily I will have before the chapter some erudite statement by folks from an article, things like that. This year, I'm changing it. It's poems written by young people about environmental justice, each chapter, because I think it's so important for the young to get involved. And those were kids who were part of a competition that was managed by the Environmental Protection Agency in Illinois. But, you know, I thought that the poems and thoughts and ideas were incredibly important. So I say to the young people, whether or not in graduate school or in law school, put on your thinking cap, take it a step further than where we are at this particular point. Put these laws together, and as a matter of fact, try to make a difference as far as getting an environmental rights amendment in your state and in other states. The movement, the environmental movement, continues. As I said, in 1980, 86, you looked at hazardous waste, but there's so many other issues right now that require the attention. Climate change, climate justice, environmental justice. It's happening to us all. So move forward as far as move the environmental movement forward. It's not just about bugs and bunnies and protecting bugs and bunnies. It's about protecting people and protecting humanity. That's where the fight is at this particular point. So I say to the young people, move forward, push the environmental movement forward, make it relevant at this particular point in time, and focus on human health, because that's where the fight is at this particular point.
All right, and on that inspiring note, I think we are unfortunately out of time. Thank you, Barry, so much for your very enlightening talk, and for your work, for the book, for everything that you have done and are continuing to do. We're really extraordinarily honored that you came to speak to us at Boston College here today. And I hope particularly the young people, the students in the audience, will take Barry Hill's exhortations to heart, and that his perspectives will inform your own professional and personal development. So please join me in thanking.
Thank you, David, and everyone be well and be safe.
Yeah, next time in person. Next time in person.
Absolutely.
Okay, thank you so much. Can't thank you enough.
Okay, bye-bye.
Bye-bye.